So this is Stuart Keatley, represented by Mr. McCreary, and then we have Tammy Swafford, who's represented by Northwest Justice Project. Ms. Waldvogel is present for that matter. Cause number is 262-00318-08. Just so the parties are aware essentially where the court is at. When we were here back on the 3rd of April, was that the last one? Yeah. We had a conversation essentially about sending the matter over. We understood that Mr. Kiernan was potentially working on an agreement, but then I'll also note that I did receive yesterday a declaration of Tammy Swafford that provided a pretty extensive information related to the allegations that she has, the potential damages that she has. And so I did review that. There was also an answer and affirmative defenses and also a motion to stay the proceedings that was provided as a bench copy to myself yesterday. So I reviewed all that. So I'm going to ask Mr. McCreary first, what's your thought about what we are doing today?
Well, Mr. Kiernan and I were headed towards an agreement, and unfortunately that's now off the rails apparently. And so I guess the way that I would summarize this situation is the answer that was provided purports to claim defenses, and if those defenses are taken by the court as defenses that amount to the need for a trial, then the court would simply set a trial today or put us over to the trial setting docket. There are a couple of reasons why I don't think that this is appropriate for trial, and I think the court should enter an order for a writ today.
Okay.
First of all, the claim is made that this is subject to RCW 5920 under the Mobile Home Manufactured Home Landlord Tenant Act. That is not the case because this is not a mobile home park. Mr. Keatley owns separate parcels of land. It's either 2 or 3 of them on which he rents the land, and people have placed their mobile homes on there and rented the land from him. The definition in 5920.030, subparagraph 13, for mobile home park / manufactured housing community means any real property. And I would ask the court to focus on that language. Any real property. We're talking about a specific piece of real property. Here, there's a specific piece for Ms. Swafford's trailer and a specific piece or pieces for the other trailers that are out there on Keatley property. So this isn't one unified piece of property. And then it says, which is rented or held out for rent to others for the placement of 2 or more mobile homes. So I don't see how that statute can be read to say anything other than 2 or more mobile homes on the same piece of real estate. And, you know, if we define real estate by legal descriptions, parcel numbers, and so forth, and there is only one piece of real estate here and one lot or one manufactured home on that piece of real estate. So taking the analysis that this is a mobile home park because Mr. Keatley owns other properties that might have mobile homes on them is a false reading of that statute. And I think the way I've put it in looking at this case is, if he owns another piece of land in Cathlamet and there's a mobile home on it, is it now a mobile home park from Castle Rock to Cathlamet? Well, they're separate and distinct parcels, just as the ones next door to this one are. And so that isn't what was intended under that definition, and I don't think that's what it even says under that definition. But in the answer, that's the position that the defense has taken to try and shift this into 5920 instead of 5918.
So let me ask you a question. Is it your contention that Ms. Swafford's trailer that she owns is on a lot and that's the only mobile home that's on that lot, or are there more of these trailers that are contained within that particular parcel?
There are no other trailers contained within this particular parcel.
Okay.
it is a single tax lot, separately sellable. You remove the mobile, build a house on it. There's no other trailers on the ground that you sold to the person who built their house.
Okay, because in the contention from Ms. Wofford, it says conjoined with my lot are two other owner occupied homes, but your client's contention is that those are on separate distinct lots as well?
Correct.
Okay. Okay, thank you for that. That was just a thing that I had highlighted, wasn't quite sure. Okay, go ahead.
Right. And I guess in some ways it's understandable to say, okay, well, there's three manufactured homes and one guy owns all the lots that they're on and they're near each other. But that doesn't make a mobile home park, and I think the definition helps flesh out why that's correct. Because the fact that they're neighboring doesn't change that they are different lots. So with that, we're under 5918. This is residential landlord tenant law. My client owns dirt and Ms. Waldvogel's client owns a structure. And she chose to put her structure on the dirt and pay low rent for having it there, and had total control over her structure. When there is a ton of dispute over what has gone down in terms of the well and in terms of water. And I think one of the telling factors is their exhibit, what is it, Exhibit A or Exhibit B, says, and this is the rental agreement, and I guess I would point out the top of the agreement says mobile home space rental agreement. That doesn't say mobile home park space rental agreement. So it's a space where you can put a mobile home, but it doesn't mean that this is a mobile home park subject to 5920. The second sentence says tenant shall maintain salt and water softener, keep the lawn mowed and premises in presentable condition. The filtration of the water was the responsibility of Ms. Swafford. And now she comes to court and complains about the quality of the water. My client has a well. He has a water filtration system on it. Ms. Swafford is the one who can solve that problem, but apparently chose not to. Where that matters in 5918 and why I don't think this is appropriate for a trial is that we have RCW 5918-100 that says that the tenant can notify the landlord and withhold a certain percentage of rent and so forth if they don't like something that that's on the landlord. Well, first of all, it's not on the landlord. It's on the tenant, who is responsible for maintaining the filtration system. But second of all, she didn't follow that process in 5918-100. The other thing that she did was Ms. Swafford purchased a cistern, a giant tank, and had people come in and attach that tank to a pump system that feeds water out of the giant tank. And now she claims she spends $300 to have the tank filled with water that's to her liking. When she did that, she cured any habitability problem. She can't say the water is bad on this property, therefore I have a defense for non-payment of rent, because she cured the problem by putting a tank on the property. She didn't do it in a way that says she should be reimbursed for it. She could sue the landlord separately for that potentially and say, hey, I should get money for this. But it doesn't mean that she has followed the 5918 requirements in order to withhold rent. And that's why this is a rent eviction. There's another step within 5918 or another potential step, and that's 5918-115. And that's the rent escrow process. And in many ways, it's similar to 5918-100, but it pinpoints plumbing and, plumbing defects and lack of water and that sort of thing. And what it says, and that's under subsection 2 that it highlights, 2A, it highlights plumbing and water issues. But then you go to subsection 2G, and it says this section shall be the exclusive remedy available to the tenant regarding defects described in the certification under subsection 2D. And then 3, the notice to the landlord of the rent escrow under this section shall be a sworn statement by the tenant in the substantially the following form. The tenant here hasn't followed or used the tools that are available to her to say, hey, my landlord has a bad well, I don't have good water, and so here's what I can do to get the landlord to make that happen. What she chose to do was to just spend money apparently on a cistern, a giant tank, and pay for water to be delivered. Once she did that, she gave up her right to withhold rent. So at this phase of things, um, she doesn't have that defense of habitability when she has cured the habitability issue herself and then not followed the rent escrow or withholding rent processes. So my argument is that that's a procedural mistake by Ms. Swafford, and the defense was defeated by her own conduct that she's admitted to in her declaration. And according to that, the court should do one of, I mean, I suppose two things. I have to argue some things in the alternative. I'm asking the court to sign the order for the writ of restitution today and allow us to move forward with the eviction. If the court's not inclined to do that, Ms. Swafford should be obligated to pay the $750 a month rent into an escrow account from December to the present. So that would be what, 5 months of $750. Because my client has had to reject some rent that was actually tendered during that time because it would waive the claims that are being made because she put on the checks some notation that we can't admit to.
Okay.
So those are the requests we're making today. Thank you.
So I had a follow-up before I turn to Ms. Waldvogel. Did your client receive any notice at any point during the time frame that she had? Let's see, she's been there since 2014. Did your client ever receive any official letter from Ms. Swafford indicating the concerns that she had of the water issue?
I guess pun intended, my client received a random spray of various things from Ms. Swafford. It's a bit of an inconsistent mess where my client would go over and say, hey, if you have an issue with the well, I'd like to address it. And she would chase him off, claiming he was blocking her driveway. Your Honor actually denied her restraining order case that she brought against him, trying to say he can't come onto the property because he's left in a position, he's an 86-year-old man who doesn't want any tenant to have bad water or no water. But when Ms. Swafford comes out on the front porch swinging her cane around and calling the cops, it makes it hard for him to do anything meaningful.
Okay, thank you for that information. I'm going to turn the time over to Ms. Waldvogel, and I'll tell you where the court's starting at here. I think the question is, you know, there are a lot of allegations on both sides, and so it's a question of, does the court make a decision today based upon what I have in front of me, or does the court in the alternative believe that this is a circumstance that needs to set it for a trial, and then we look at what potential escrow would look like. So that's I think, legal issue that I'd like you to focus your comments on, because I think we have to make a decision about that, and if this is a trial worthy case, or if the court believes the contentions from Mr. Keatley and makes a decision based upon those arguments.
Thanks much, Your Honor.
Mm-hmm.
So as the court has heard, Ms. Swafford has lived in the home since 2014. It's a home that she owns. She rents the property on which her home sits from the plaintiff. There are two conjoining properties. So under RCW 5920 and the case Allen versus Dan and Bill RVs Park, 6 Wash App 2D 349, and I quote, any real property which is rented or held out for rent to others for the placement of 2 or more mobile homes, manufactured homes, or park models for the primary purpose of production of income, except where such real property is rented or held out for rent for seasonal recreational purposes only and is not intended for year-round occupancy. So that is how a mobile home park is defined. I don't know if the court is able to see. Unfortunately, I don't think so, and I only was able to obtain this document this morning, but it says Cowlitz County net map, and there are actually 4 different lots on here: lot 1, lot 2, lot 3, and lot 1A. So truthfully, so I guess there's that, and I do feel that there is a significant amount to be unwound regarding how 5920 defines real estate. Some of the arguments Mr. McCreary made, he said the lease agreement or the rental agreement refers to space. Well, when we're in a mobile home park, that's exactly what mobile homes sit on. They sit on space. He makes an argument that if his client owned homes, I think from, Castle Rock to Woodland, one was in Castle Rock, or piece of property in one city and then another piece of property in another city, does 5920 apply? No, it doesn't. Here we have a different situation, however, because the three lots that are currently renting out, the 3 lots that are being rented to mobile home park owners, like I say, they're conjoined. Lot 1 touches lot 2, and then lot 2 touches lot 3 and lot 1. So the rental agreement here clearly states the landlord needs to maintain the well and the septic, but since 2017, things actually got much worse in 2019. That's when my client started making complaints to the plaintiff that she's had problems with the well and the septic that have gotten so bad she had a cistern delivered to the property in December of 2025 so she can enjoy fresh and safe water in the home. She has incurred at least $24,932 in expenses since 2019 as a result of the faulty water and the failing septic, and this does not count any possible damage to the pipes in her home resulting from the faulty water and the septic. So the plaintiff owes my clients thousands of dollars. That more than sets off the rent payments that were not made in December and January. She attempted to tender rent starting in February. That was refused by the plaintiff. So we're requesting this matter be put on trial settings so we can properly get it scheduled for a jury trial, responding to a couple of Mr. McCreary's arguments. If for some reason, if the court finds 5920 doesn't apply, then 5912 does. And I don't know that any of those provisions that Mr. McCreary references in 5918 would apply. Number one, I can't say for certain if 5920 does apply if the provisions he references in 5918 do apply, but I will say that my client is not required to do any sort of rent escrow. This is a straight habitability issues. The habitability issues continue. Ms. Swafford was able to remedy the water situation on her own. The septic issues still remain as recently, as current. There's still an issue with the septic not working and sinks filling up with water. And Mr. McCreary references the salt. That's another issue that's disputed. My client said at a certain point the salt was the salt system was taken out. So this certainly is not just an issue of my client not putting salt in the water softener. If it were that simple, there would have been no need for her to have a $4,000 cistern developed, set on her property. I appreciate Mr. McCreary's passion. I appreciate his desperation to try and get a writ issued today. He refers to his client as an 86-year-old man. My client is, she is a cancer survivor, and she's undergone significant surgeries and procedures during the course of her tenancy there. She's given lots of notification to the landlord.
Can you tell me more about that? In what way has Ms. Wofford communicated this with Mr. Keatley about the issues related to the water concern?
Sure. So my client she's given verbal notice. She has given notice by text. She's given notice in person. She's given written notice. The dilemma here is that my client, she recently had carpal tunnel surgery. She had her cast off yesterday. And as she put in her declaration, right now she's just having a hard time accessing things that are on her computer. But generally how this, the relationship between the parties, I mean, first of all, they do have a long history, number one. My client started with giving all kinds of verbal notice. I mean, it was just every time she saw Mr. Keatley, she would describe the problems. So it was just kind of an ongoing situation that was occurring. There was a letter that my client sent in 2023, even though I know there was earlier written notice that it looks like I did not include, and it was only inadvertent because I was trying to get a response out on short order in 2023 that was very specific with all of the issues that were ongoing. And also, again, I don't want to deviate from the court's question, but, I think it's been a pissing match between these two, where Mr. McCreary claims, that his client is chased off. My client has had significant habitability issues. She makes requests to Mr. Keatley. They fall on deaf ears. So she takes matters into her own hands to make the repairs herself. And then it gets Mr. Keatley's attention. And then he chases her people off, and then he'll bring people on with no notice to Miss Swafford. So it's kind of a hot mess, but that doesn't change the fact that there have been significant habitability issues. My client has expended a significant amount of money that she should not be required to spend. The equity in her home is significant, and for the court to enter a writ today on short order without the statutory trial that my client is entitled to would violate the law, because clearly we have disputed issues of fact. We have a lot of them. So I would ask the court deny Mr. McCreary's request for writ, put this on for trial setting, and then we will get a trial date.
Mr. McCreary, what's the RCW contained about rent? I'd like to look at that before issuing a decision. Specifically to like an escrow, if the court grants the ability for it to go to trial, requiring the tenant to place that into an escrow. Can you give me the site for that again?
It was 5918-115.
Thank you.
And my point on this one is that she has effectively withheld rent as a rent escrow without following the requirements of the statute. And so my argument is the court should impose that escrow requirement at a minimum so that that rent has been held aside for this purpose.
Okay.
Subsection 4 talks about holding it in an account.
Is that usually paid to the clerk's office and held for the disposition at the trial?
The statute actually calls out putting it in an escrow account in a bank or savings and loan
Oh, they do.
within
Oh,
Washington,
okay.
yeah.
Okay. Okay, so here's what the court's inclined to do. I did look at the parcel thing. I believe that's what Ms. Waldvogel has too. And you can see on Chapman Road that there are 4 lots. The, public records allow for access to essentially what the plot map is and legal description of those. But the court isn't making a determination right now as to if this is applicable under the Mobile Home Act or the standard Landlord Tenant Act. It does seem that it would be leaning towards the Landlord Tenant Act just because of that layout, and that there's not additional mobile homes on each of those particular lots. But I would agree that given the case law that Ms. Waldvogel has reported, and there's been an extensive amount of litigation about that particular issue, that's an issue of fact. I think the other issues, the bigger ones, I think that's a slight one. Court could likely make a determination on that today, but the bigger issues are more concerning as to, we're looking at an issue related to water, which makes it not an inhabitable residence. And if the court were to look at specifically imploring the Landlord Tenant Act, that this is a circumstance that needs to go to trial. I agree with Ms. Waldvogel in that this is a case that has a lengthy history of concerning events. And then I appreciate Mr. McCurry letting me know about the protection order that I heard. That gives me as a judicial officer in this case a little bit of pause as well, in that when you're determining a particular issue, and we're not here for the protective order at all today, we're only here for the issue of, do we issue a writ or do we not, or do we send it to trial and proceed in that fashion? There's information that I, as a judicial officer, heard at the time of that protective order. I don't believe that it raises to the level where I have to enter a recusal in this case, but it's borderline a little bit concerning, knowing that I was provided information that is specific to the party's contention. I don't think that that's a secret. I think it's accurate that there's a significant amount of contention. And I'm giving Ms. Wofford a little bit of grace because of a few things. She did indicate in her declaration that she recently had carpal tunnel surgery. I know that she indicated medically that she had cancer previously, but it does sound like that was some time ago. But with a recent surgery, a recent issue related to a computer and potentially getting documents that the court potentially could have looked at. And the biggest issue that the court has is about this habitability issue related to the water and the contentions that Ms. Wofford has. The first thing that I wrote down on this case is, do we need to go to trial? The answer is yes. That's where this case needs to go. And I know that places Mr. Keatley in a disadvantage, because we're looking at potentially, when do we have the trial? We want it as soon as possible, but we also have to work around the court schedule, the court availability, and all that comes with that, which both attorneys have been here for a long time and know how that process works. So I absolutely want to have the rent money placed into an escrow account, because at the end of the trial and the decision of the court, depending upon what the ruling of the court is, Mr. Keatley should not be financially damaged if that rent amount that he's not currently allowed to collect because of this pending litigation needs to be placed into an escrow account. December, January, February, and March, potentially in April, depending upon when that was needed to be paid. Those need to be placed into an escrow account so that they can be sitting there waiting on the decision from the trial court. I know that Ms. Wofford has contentions that she paid out a significant financial amount of money, and that potentially is a legal issue that can be addressed at the time of trial. But Mr. Keatley shouldn't be financially precluded from accessing those rent amounts just pending a litigation case. So I am going to set it for a trial, but the rent needs to be placed into an escrow account pending a final decision from that judicial officer.
And excuse me, Your Honor, when you say an escrow account, is that like depositing the money with the court?
The statute that I was just referring to specifically looks at under RCW 59.18.115. In other cases, I have heard that it goes into the clerk's office, but this statute is specific in that it talks about in section 4, the escrow shall place all rent deposited in a separate rent escrow account in the name of the escrow in a bank or savings and loan association domiciled in this state. I'll ask you, Mr. McCurry, do you have any suggestions as to, is that account something that you already have access to, or does that new one need to be created?
Well, it would be a new one needed to be created, but that's in the course of actually performing a proper rent escrow, which wasn't done here. And I'm sort of asking the court to substitute for what failed to happen. So I would think paying it into the registry would be an acceptable approach.
Okay.
And I guess I would also want to know if the court has conditions associated with that. I mean, all that rent should be available to Ms. Swafford since she didn't give it to Mr. Keatley. And have conditions on when it has to be paid by and what the repercussions are if she doesn't.
Yeah, we'll talk about that in a second. I'm comfortable with that, and that I understand that the statute provides for a specific account, but it is common that when the court makes that ruling and we're going to go to trial and that rent proceeds need to be paid, we'll just have it paid to the clerk's registry. That way no account has to be processed and we don't have to deal with the process of creating that. So we can have Ms. Swafford pay that to the clerk's registry. As far as timelines associated with that, first time frame we're going to do is we're going to set the parties to the universal trial calendar. What date is that on?
Wednesdays at like
Are we
9, isn't it?
doing that calendar next week? Let me double check. What's that?
And Your Honor, I guess I would also mention you talked about court calendars and timing and so forth. The statute does require us to schedule an unlawful detainer trial within 30 days.
Okay.
It's not next week.
Yeah, okay. Mr. McCurry, you usually are involved in these trials. Are they set a week of as well?
Yeah, I mean,
Okay.
I sometimes it seems like we get a specific date because it is on short order and they're wedging it into certain spaces. We have
Okay.
Fridays, the afternoons that are supposed to handle these, but I'm not sure this one's happening in the course of just a Friday.
Okay. So here's what we're gonna do. Is that not on the list for things next Wednesday because of judicial conference? Okay. Let me look at one thing. I got drafts of schedules yesterday. Let me double check that it's not on there. I don't think that it is though. If that's the case, then I'll just stop off for a second and go talk to court administration. Because it's not appropriate to wait 2 weeks to set this.
And Your Honor, we will be filing a jury demand.
Okay.
I've set these on dockets before, so we could set it right now.
Okay. We're gonna go off the record for about 5 minutes. Give me a moment. I'm gonna go double check with court administration and we'll be right back. We have the record. Here's what we're gonna do with this case. We are going to put this matter over to Tuesday, April 21st at 11:30 a.m. That we have a unique schedule next week because it's judicial conference week and we have a number of judicial officers who are out for that conference, but we do have the universal readiness docket. At that point in time, we have a judicial officer. We also have court administration who I just spoke with, and they indicated to put it on that docket. There's a potential that we could work it in if the parties are ready. It potentially could go next week, although if we have a request for a jury trial, that's of course going to take a longer period of time, but in the very least, it can be in front of a judicial officer and court administration. And if the parties can find a date that week, great. If not, they can give you a trial date at that date and time. That way we're not waiting 2 weeks to actually set the trial date.
Appreciate it, Your Honor.
Okay. Okay. Thank you to the parties for all your information. So the ruling on the court is we're going to set it for a trial. Because of judicial conference, we're going to put it on that universal readiness calendar. The rent needs to be paid. And as far as timelines associated with that, I'm going to make a court ruling that those rents need to be paid prior to the trial date because we don't have a trial date at this point, or in the alternative 30 days, whichever of those is occurring last, because there is a potential that the trial date could be held before those 30 days. So before the trial occurs, Ms. Swafford needs to have that amount paid for. If there's a concern about financially not able to meet that court order, we don't want to be in a circumstance where potentially Ms. Swafford is precluded from providing any information at the trial by not paying those. She can address that with whoever is going to hear the trial, but it needs to be paid within that time period. absent further rulings of the court. If she wants to provide some kind of financial information, which the court doesn't have, but a 30-day window to make those payments is a reasonable time period, especially because had we not had these discontentions, would have already been paid, and presumably she has those funds. So that'll be the ruling of the court. It needs to be paid within the court registry by 30 days.
Thank you, Your Honor.
Okay, thank you to the parties.
Thank you.
We'll mark that one complete.
It's Ms. Walpole. I apologize. I thought it was Mr. Kiernan.
Your Honor, Mr. Kiernan is on vacation, so I'm covering for him.
Ah, understood. Okay, this is number 10 on the docket, 26-2-31808. Keatley v. Swafford. I know it's somewhat unusual at reviewing the notes. It looks like you all were set for trial assignment to this docket. Is this case expected to go to trial, or I'll let the parties fill me in?
We're scheduling it for trial because of the argument that was had last Friday regarding the unlawful detainer matter, and the plaintiff is entitled to a trial within 30 days. The Wednesday trial assignment docket is off because of a judges conference, I believe. So Commissioner Foster put us over to today after consulting with, I think, the clerk's office.
Okay. And if I understand, and I don't have it pulled up in front of me, it's the entitlement's 30 days from the date trials requested, correct? Is that the 30 days start that we're looking at?
I don't remember the exact wording of the statute. It's within 30 days. I don't know if it's of the show cause hearing or of the date the trial is set. I'm fine with either. I'm not going to quibble over a couple days.
Do you know where, do you know how long you'd be looking for and what week you are looking to get this done?
Ms. Waldvogel indicated that she wanted a jury for this one, so I would expect it to be 2 days. And anytime within the 30 days is fine for me.
And Your Honor, I have, just because I have, so I kind of have a hopscotch or checkerboard, you might say, calendar. I'm trying to do this at a time that either Mr. Kiernan or myself is going to be available for trial. So, and my client has some dates that she's unavailable as well too.
But I don't see a jury demand. Was it filed and just hasn't been scanned in yet, or?
It was filed on Friday.
Oh, okay. And is it a jury of 6 or 12?
A jury of 12.
Okay. And how long do you think that you need?
I think 2 days is a good estimate.
Okay, and then, so Ms. Waldvogel, what week are you looking at within 30 days approximately?
Your Honor, thank you for that question. I was going to kind of let the court wag the tail on that. I didn't think that I'd actually have a choice because usually when I come to trial setting, it's really just being a matter of presented with what's available. So I guess since the court is giving me a choice, I would say, give me 1 second.
You want to set it for week of May 18th. And then what I do is have you come back on readiness at 11:30 on Tuesday, May 12th.
That would be acceptable to me.
That works.
Okay. Okay, we'll have you back May 12th to confirm those dates of week of May 18th. Okay, thank you both.
Thank you.
Thank you.